Yes.
Yes, good morning, my lady. Good morning, my lord. I appear this morning on behalf of... sorry, my instructing solicitor. I appear this morning on behalf of X and Y.
Yes.
The children in this case. To my right is my learned friend Mr Barnes, who represents the BBC. Then there's Miss Strong, who represents a local authority. And last but not least, my learned friend Mr Jarman Casey, who represents the carer. Just in terms of introductions, I know that your ladyship certainly has been proactive in terms of the appeal, and that various things have arisen over the last couple of weeks, which I will come back to in a moment.
Certainly.
Essentially, this is an application for permission to appeal the order of Mrs Justice Lieven dated the 20th of January, which followed on from a judgment she delivered, or rather handed down, on the 14th of January. That judgment appears at page 23 of the bundle, which I hope you have.
We do, thank you.
And essentially, it arises out of a hearing that took place on the 6th of December, an application by the BBC, firstly for disclosure of various documents from a set of proceedings, and secondly, to report on those documents. And so it was that on the 6th of December, the parties, other than the BBC, all the parties opposed both disclosure and then publication and reporting. And before I go into the grounds of appeal that were filed at that stage, they were filed very quickly, my lady, because the judge had indicated she was going to publish her judgment on the 17th. So the initial grounds that you had, which are in the bundle at 19, set out what the position was then. In recent days, and everyone is grateful, your ladyship, in fact, sent out a question that has posed all of us to contemplate, which is, and we've done additional submissions, which I hope you've also had an opportunity to read.
Yes, we've had all of those, thank you.
I'm grateful. Essentially, adding to, and of course I need to seek permission to amend the grounds of appeal, and on Friday you should have received amended grounds of appeal.
We did, thank
separately.
you.
In terms of that, if I can just generally set out what that was, in terms of the open justice principle and your ladyship's question about whether or not it fell within the walls, if I can use that phrase, of Dring, or within the definition, those grounds essentially seek to add on to the previous grounds that the information sought by the BBC did not fall within the purposes of the open justice principle as set out in Dring. The private fostering arrangements had ended before the commencement of court proceedings or any involvement of the family justice system, and did not form any part of the court's consideration and decision making. And finally, that during the course of the judgment and as part of her reasoning, the parameters of the open justice principle were extended to include workings of local authorities and the wider child protection system, which we would say is out with court proceedings. So that is the ground upon which we seek permission to expand our previous grounds of appeal. The way that we've discussed this morning how that might go is that, with your permission, of course, my lady, is that we deal with that as part of submissions, and then in turn people can respond to that, and then obviously, unless your ladyship has a different...
No, I'm happy to deal with it however all of you want to. Do I take it, Mr Barnes, you're going to object to the amendment?
Well, I'm my lady, I'm somewhat relaxed. It really depends on the court's approach. There is no difficulty in the matter being argued. In a sense, if my lady is with me, the permission should not be granted on that particular amended ground, then it may be that that's where the point rests and is most convenient for the court to consider, rather than dryly trying to prevent my lady and my lord from considering the issue, given that it's obviously a matter that the court raised as causing concern. So I hope that's a pragmatic way.
I think that's sensible, yes. So we'll amend it, we'll give permission to amend now, and then of course we'll hear your arguments about whether permission to appeal should be granted in respect.
Thank you. I hope that's a more convenient framework and more realistic. Thank you.
And it saves time. Thank you.
My lady, just by way of backdrop then, without going into the details, many of which, of course, we should not be mentioning here, but in terms of the backdrop to the application that the BBC made, it's important in our submission that the court understands what I'm going to call the evolution or the morphing of the BBC's case as to what they were actually going to wanted to report on. And the first application, of course, which was amended to our amended grounds, was that dated the 4th of October. So this was before Mrs Justice Lieven on the 25th of October, in fact, when she had the first hearing after the application had been transferred from the West London Family Court. At that point, the BBC's nucleus of their application was essentially to report on what had happened in court proceedings, decisions reached, assessments and the like, and that accorded with transparency of the family court. So in essence, what they were seeking is to report on court proceedings.
Understandably enough, seeing they knew absolutely nothing.
Exactly. And so what happened then is that I wasn't there on the 25th of October. I've come in latterly, but Miss Hendrick, who sits behind me, and I don't think, to be fair, Mr Barnes was there on the 25th of October, or indeed Mr Jarman, but certainly Miss Strong may have been.
All down to you, Miss Strong.
That's not, as it were, an attempt to say that everything falls on Miss Strong's shoulders. But certainly at that hearing, I understand that Mrs Justice Lieven did hear some submissions around the fact that there were no proceedings and the understanding of that. And it was on the back of that that the BBC were then given permission to amend. So what they did is they went away and they then amended their application, which was also exhibited to our amended grounds. We think it's not dated, but it's around the 8th of November. And in that, the application there was expanded for the BBC to, quote, examine findings of fact and any value judgments made by the court and the local authority when scrutinising placement. So it had slightly changed. However, by the 6th of December, and only in the skeleton argument dated the 4th of December, which I think from memory had to be filed by 4 p.m, was the nucleus or the central focus of the BBC's wanting to report widened to include private fostering arrangements, the effectiveness of them, and whether or not a local authority had oversight of the same and how they carried out that function. And so it came to be that it was at that hearing that everybody understood, and that's one of the reasons why it wasn't dealt with in these skeleton arguments by the others, because they didn't know really until that hearing that was happening. So this is the, I suppose, the evolution, as I called it, of the application. So it went from shining a light on court proceedings and what judges did and decisions made to, well, let's look at the wider system, and particularly in this case, private fostering arrangements. And so at that point, in our submission, that hearing really did predominantly focus on private fostering arrangements, the nature of them, how they were dealt with in terms of reporting, i.e. it was said very little, and the open justice principle, as important as it was, faded into the background a little.
Sorry, can I just interrupt you? It's just occurred to me, of course, that we are live streamed, and I haven't reminded those that are on the live stream that there is a reporting restrictions order in effect, and it can be obtained from the press office if
Thank
required.
you, my lady.
So I'm sorry to interrupt your train of thought,
No, not
but it
at all.
just suddenly occurred to me.
And I think it's fair to say that there's a level of concern at the bar about, because the reporting restriction order is obviously quite properly there for a reason, but certainly we, if we do speak cryptically, your ladyship will understand why. I hope that certainly everything that I say is understandable from on the basis that you've read the papers, and I don't intend to travel through a lot of the history.
No.
And so it was on the 6th of December that Mrs Justice Lieven came to look at that as being the basis for what the BBC wanted to report on. Just dealing perhaps with your ladyship's question and point, the open justice principle,
Yes.
and whether or not that of itself, i.e. the oversight, effectiveness of oversight of private fostering arrangements falls within that principle. We say, as you've seen in our additional grounds, and in fact the others say, save possibly for Mr Barnes, that it does not fall within the open justice principle. Scattered or peppered through some of the skeleton arguments, and I can take you to the references later, although I'm not sure it will assist your ladyship or your lordship, but there are points in people's skeleton arguments where they say, in general terms, the public interest point in this case is called into question because actually by the time the private fostering arrangement had happened and occurred, in fact the court proceedings came after that point. So anything that was done under the umbrella of the private fostering arrangements was not the subject of decisions by courts, judges, or looked at in any depth or on any level in the court proceedings before the court.
So was it being suggested that the proper approach would have been to make an application under the Freedom of Information provisions to the local authority?
And I certainly understood, and Miss Strong may have to help you with this, that on the 25th of October, which was when the case first came before, came before Mrs Justice Lieven, different avenues in terms of how documents that were held by the local authority were to be seen would have to be explored. But I can't tell you, my ladyship, I'm afraid, your ladyship, as to whether that was specifically raised on the 25th or not. But certainly the position of the local authority was that those documents fell outside anything that were court proceedings. So in terms of the open justice principle, quite properly, the case of Dring featured, in fact, before her ladyship, but in a different manner, perhaps, in the sense that what one was taking her to was a reminder of the balancing act in Dring at paragraphs 45 and 46, which is on the one hand the purpose and the value of the information, and on the other hand the risk of harm to others, including of course the protection of the interests of children, which is what the Guardian was particularly concerned about for all the reasons that you've seen in her analysis. But if we look at Dring, and if you have an authorities bundle, it's at 264 of that bundle.
I'm saying quite astonishing authorities bundle for a 2-hour PTA hearing.
I have to say what we've discussed latterly, and it was that credit needs to go to certainly our instructing solicitors, because there was a lot of, I think there were over 30 or 40 emails on Friday as to various authorities and authoritative citations, and so a lot of hard work was put into it. But I think the view at the bar is that if this court were to see fit to grant permission, then we'd have to really review that quite sensibly if the case were to go.
All right, so we're
at 264, but actually the paragraphs which various of us have referred you to in our additional submissions fall at 272, starting with paragraph 41.
Under discussion.
Indeed.
Thank you.
And so this is discussion of the open justice principle and what it consists of, and what it actually means in terms of transparency and what we are trying to show to the outside world in terms of how family courts in particular operate the open justice principle. And in our submission, it is quite clear there from Lady Justice Hale's discussion that it's about courts and tribunals who are exercising a power of the state, and also the judges who operate within that sphere and administer justice. So in essence, the spotlight, when we talk about the open justice principle, falls squarely onto what is happening in our courts. The family justice system is the system by which justice is administered in family cases, and the people who do that are, of course, the judges, and what goes on, forgive me, in the courtroom. And at paragraph 42, it's two-pronged, the approach there, and I accept that Lady Justice Hale says there may well be other purposes, but if you look at the two prongs, they're very clear. It's public scrutiny of the way in which the courts decide cases, to hold the judges to account for the decisions they make, and to enable the public to have confidence they are doing their job. Well, in this case, just pausing there, the issues and the details about which Mrs Justice Lieven was considering never found their way before a judge who made decisions and considered the evidence and made value judgments about these aspects, i.e. the private fostering arrangements. No judge in this case ever grappled with that issue. So the open justice principle, in terms of a courtroom in which anything to do with X and Y took place, did not consider those issues. So we say that the open justice principle, the central plank, in fact, of the open justice principle, is what goes on in our courtrooms, how is justice administered, and are the judges doing their jobs correctly based on the evidence that comes before them, i.e. the decisions that they have to make on the evidence and the issues. If you move to paragraph 43, it says the second goes beyond the policing of individual courts and judges to enable the public to understand how the justice system works and why those decisions are taken. And what that paragraph goes on to say is what happens in terms of the evidence that comes before the court. Because evidence comes in two forms, certainly as is noted there, in the old days it was oral, but now it comes in written material. And we say that the judge dealing with these proceedings had barely any evidence that trespassed or embraced the issues of private fostering arrangements. In fact, we would go so far as to say there was little, if any. In fact, it was not discussed during the proceedings what that arrangement was. Private fostering, kinship, placement, whatever word we use, that was not something that the relevant judge at the time was grappling with. So we say the underlying ethos of this case is that it's the workings of the family justice system, the workings of the court. It's not the wider child protection system. And that's where we say Mrs Justice Lieven fell into error when she was contemplating that, because what she said was that the family justice system incorporates courts, well that's certainly in alignment with DRING, but also the wider child protection system.
Is that what she said? Because I was trying to understand in what way she approached the DRING principle. Because she talked about this case in paragraph 51.
51 is the main one, yes.
There is a real public interest in reporting on this case and the circumstances which led to the children being in the care of the mother's friend.
Yeah.
Now, this case wasn't to do with how that circumstance came about. This case happened after the mother's friend ceased to be involved.
Yes.
So is it your submission that when she's talking about reporting on this case, she's talking about something other than the litigation, something broader?
No, I think what if you travel down paragraph 51.
Secondly.
Yes, exactly. Firstly, she says the president of the family division has made clear there's a strong public interest in better public knowledge and understanding about the working of the justice system. And then if you go on there is an attachment, which I can come back to, of the courts and local authorities working within it. That's the first point. Right. But as the ladyship's just pointed out, is the secondly point. So this was a branch of Mrs Justice Lieven's thinking and decision making, is that it raises a little known issue within the Children Act, i.e. private fostering arrangements, and local authorities' duties of oversight over such arrangements. And she then goes on to say, well, it doesn't come before the court very often. It's not subject to court oversight. And so the media, therefore, have a big role, a greater role, in shining a light on that.
Well, that's what puzzled me. She uses this case twice in this paragraph. First in the passage that I mentioned earlier, and then the second time, after the word secondly. This case raises a little known issue. And this case, in the narrow sense, the care proceedings, your submission is that this case doesn't raise anything to do with that because the judges weren't concerned with it. No. And she says in terms that private fostering arrangements are not subject to court oversight.
Indeed, and they're not.
So it seems to me that arguably she is using this case in a much broader sense than meaning just this bit of litigation under the Children Act.
Yes, I think that's an interpretation.
Or she
certainly.
meant this application.
Or she meant
Yes,
that
might be the better phrase, or the word, forgive me. But in essence, what we say about this is that the umbrella of the open justice principle, and even when you look at the President's transparency guidance, it's about the workings of the family court. It's about the workings of the judges. The family justice system, in terms of looking at this, private fostering arrangements, as you've already said, my lord, do not fall within the court's oversight, in the same way that Section 17 duties or Section 23 duties under the Children Act don't. But that they would never necessarily come before a court upon which it would be adjudicated upon, because that lies in a tranche of local authority functioning. And we say that not just in this case, where it wasn't before the court, but more generally, that open justice principle doesn't apply to things that are happening outside of the proceedings if they were never, ever brought before the court and dealt with in those proceedings. It's stretching that open justice principle too wide, even though Lady Justice Hale says in terms there may well be others. They have yet to be defined.
But there are other ways by which members of the public, including journalists, can get hold of information held by public authorities. Most notably and most obviously the Freedom of Information Act.
Freedom of information.
And I gathered from what you said earlier that the local authority doesn't actually have a position on whether this application should have been framed in some other way and might have been legitimate.
Yes, I mean, Ms Strong will have to, I think, deal with what the local authorities
Sure. But
position
do
was.
you, on behalf of the children, have a position on that?
I think that the other avenues were the better avenues to take, and the freedom of information is obviously the main one, and that would be potentially from the BBC's perspective a legitimate avenue of exploration in terms of freedom of information. I think the issue for on behalf of the children has always been that there are two central planks of information, which obviously I will not go into, but those central planks, which are not in the public domain, because they're not in the public domain, the Guardian has wanted those not to be in the public domain. So from that perspective, I think that's where the Guardian's focus has been, which is why that formed part of our first ground of appeal.
So I think if it went down the freedom of information route, it would be the local authorities' responsibility, at least in the first instance, to take a view about whether the information was exempt or how third-party rights came to be taken into consideration.
Indeed.
And the Guardian might, I don't know quite how that would operate, but the Guardian might or might not have a role in that.
I think probably not have a role, although it's fair to say, and I think this is something that certainly appears in the documents, is that the Guardian, in terms of the local authorities' position, was the one who suggested, or certainly was behind a review, a learning review. So that was an avenue that, although she couldn't participate in, she was very supportive of. And we would suggest that that's another avenue under which the local authorities' functioning or actions would be viewed, rather than in the courtroom in this case, where it wasn't viewed. There are other avenues basically open to the BBC, not via this pathway of the open justice principle, which we say, if you're looking at Dring and you're looking at the wider understanding of open justice, something that happens before court proceedings ends and then the court proceedings start does not, we say, fall into the parameters of looking at the family court system or the family justice system at that point, because it's not within the family justice system. So we say that, in fact, the point raised about the open justice principle is a valid one, and that it doesn't include, we would say, in this particular case, it never did, the private fostering arrangements. And although the BBC's applications morphed or evolved, it was wrong of Mrs Justice Lieven to then extend the parameters of the open justice principle to provide a pathway to have oversight of the local authorities' actions, whether they be safeguarding actions or otherwise. it goes without saying that the open justice principle is to do with public confidence in how that family justice system runs. And of course, a recent case in which you were both part of the Constitution, in terms of Tickle and the BBC 2025, this is about who is making the decisions and the confidence in the system generally. And by that, I mean the system of family justice, not the system of how the local authorities work, not how private fostering arrangements work, not how Section 17 or Section 23 duties. It's a completely different thing. And it's wrong to shoehorn those aspects of a wider child protection system into the open justice principle. It simply doesn't stand. In terms of that, I think that we would suggest, we would urge the court, in terms of that appeal, that to give permission, because that is fundamental, we say, to an understanding of how the gateway would open, or the door would open for the BBC to be in court asking for this in the first place. Because if the court takes the view that the open justice principle does not permit for that sort of oversight, and it's the wrong focus, because it should be the courts, not the local authorities coming through it or passing through it, then we say actually the application, as I understand, which was first addressed on the 25th of October, wouldn't have got through that gateway because it would have failed at the first hurdle. It isn't included in the open justice principle. So in terms of that, and looking at, at the time that we have this morning, my lady and my lord, that's what I propose to say about that, and how this case, the private fostering arrangements, do not fall into the open justice principle.
Thank you.
Simply doesn't apply. My lady, just briefly then, can I do what I'm going to call, if I may, without being flippant, a whistle-stop tour of the other grounds?
Certainly.
The first one, of course, and this is at page 16, although the skeleton, which is probably the best place, and I'm sure you've had an opportunity to read that, starts at 53, I believe.
Thank you.
The first one is about what information there was in the public domain. And this was important. This was something that Mrs Justice Lieven called the critical issue in this case. That's what she saw as central in terms of then going on to grant A, the disclosure, and B, the reporting. And what we say simply is that there was an imbalance in the sense that, yes, there is stuff in the public domain, but when it comes to X and Y, there is very little in the public domain. And you would have seen that Mrs Justice Lieven herself took it upon herself to Google and to find out what else there was. And at some point, and I don't think it features in the documents other than briefly in our skeleton argument, stumbled upon a Just Giving page, which in fact had been taken down. But even that, even from the judge's own research, which I know Ms Strong takes exception to and says it was improper to do that, in fact, that wasn't discussed during the hearing. It was something that we were emailed about, and then we had to write additional submissions on, which, with respect, I would suggest is highly unusual. But in any event, let's say that she was entitled to do that research. It was wrong to say that the information about X and Y in the public domain was extensive. There really isn't that much at all. Yes, there is information about criminal proceedings. Yes, there is information, we say, from an opening note, and you would have seen that referred to, when I did engage with Mrs Justice Lieven on this, because of course, although that note had been out there for some time, it hasn't been reported upon thus far. Nobody was able to point us in any direction to show that that had been reported upon.
Seems to me there was a bit of an issue in the skeletons about what is meant by public domain, which is a vexed issue in pretty much every context. The judge was saying, wasn't she, there's quite a lot of information accessible to the BBC. that they can use if they want.
Yes.
Doesn't really matter whether it's been published already. No doubt they'd rather it hadn't been, as long as they've got it,
Yes.
got access to it. And that's a perfectly valid point, isn't it? It doesn't really matter whether it's already out there in the sense that everyone knows it.
No, you're absolutely right. And there was discussion during that hearing about Section 12 of the Administration of Justice Act and the ambit of that. And actually, what Mr. Barnes was saying, and I don't, it wasn't disputed, was that under the auspices of Section 12, there was quite a lot that could go out there in any event, and nobody stood in the way of that. I think what we would say about when she came to look at the information in the public domain in respect of the wider issues, criminal, and the children per se, and information about the children, it was very, very sparse. There really isn't that information. The only two central planks, and I call them the central planks, I hope you will know what they are.
Yeah.
It's the placement, the identity of that placement, and what occurred potentially in that placement. Though that central plank, there is, thus far, it's not reported. And if that is reported, what the Guardian was saying through us is that really would cause significant harm to X and Y. And that's why we went on to say, one of our grounds, that the balance at the end of the day that Mrs Justice Lieven carried out, Article 8 rights versus Article 10, fell in the wrong direction after her reasoning. We say, if ever there was a case, and there aren't many, that's an interesting fact, but if ever there was a case where Article 8 rights to protect the interests of children, as Lady Justice Hale said in Dring, was operational, this case is it, we say. A lot of the cases that come before the court about the Article 8 rights in respect of children are speculative, or at least that's a phrase that crops up a lot. Well, evidence about potential harm is speculative. In this case, there's direct evidence, and I won't traverse into that. You would have seen it in the bundle, but certainly in terms of the children, at this point, there is very, very little information in the public domain.
Thank you.
So that we say is where she got the balance wrong on that. Can I move swiftly, if I may, my lady, to ground 2? And we say, of course, and your ladyship and your lordship will be familiar, and I appreciate that PJS, to use Mr Barnes' phrase, is the high water mark, and she did refer to that. But we sent in additional submissions again when Mrs Justice Lieven sent out an email asking for any authorities that we could send where it could be shown that in the circumstances of the case there had been further restriction of reporting when there'd already been information in the public domain. So that's when we sent in those 5 cases, one of which was PJS. Yep. Mr Barnes says, well, we don't know that she didn't consider those authorities. I can see that, but on the other side, we don't know that she did. And what we would say is that even if there was information in the public domain, that the perpetuation of that, the medium and the level of circulation, and the impact, we say, of the 5 cases that we showed with those 3 branches was never really factored into her judgment. Yes, there is information in the public domain, but actually reporting it again is perpetuating the potential for harm, but also the court can restrict things that are in the public domain. I understand the difficulty in this case when there has been criminal proceedings. But again, and this is where perhaps the curiosity is in this case, is that even with the criminal proceedings, information about the children, there isn't any. And of course that was assisted, not fully, Mr Barnes is right, the reporting restriction order that was made by the judge in the criminal proceedings preserves obviously identity, it doesn't preserve the other points, but interestingly, since that point there has been no reporting of those central planks, which we say are crucial from the children's perspective. Just briefly, trotting through ground 2, and it may be that Mr Jarman, King's Counsel, addresses you on this. It's fair to say that the carer was very concerned about the reporting on X and Y, and also factored into that was the carer's own Article 8 rights. You would have seen the medical position, which is very, very serious, and likely to cause further concern to X and Y in this case. It's fair to say that the judge at paragraph 49 of her judgment considered the oral application. It was made orally for a reporting restrictions order. But again, it was dealt with on a scant basis, we say, and didn't really analyse those two central planks and whether or not those central planks of information should be restricted. And although the judge, and it's at 67 of our skeleton, milady, where it says at paragraph 48, which reflects the judge's paragraph 49. Mrs Justice Lieven, of course, refers to your decision when you were Miss Justice King in Stedman, just at the bottom of that paragraph, where it said, and it's right, that you rejected the argument for further restrictions on the basis it would be futile. That was a very different case, if I may say so, because the parents had engaged in terms of Charlie and Alfie in respect of putting information out in the public. It wasn't the same as this case. So I'm not quite sure. We would say that's not a good comparator in terms of the sort of situation your ladyship was faced with in that case, because it would have been futile because, if I may use the colloquialism, the horse had bolted. Whereas in this case, it's very different. We've still got information that isn't out in the public domain. It's a very different case, very different landscape. But essentially, what we say there is that there was very little engagement, if any, with that application for a reporting restriction order. And actually, there should have been, because of the fact that those planks of information, as I'm referring to them, were not in the public domain. And actually, those planks of information, if stumbled upon by X and Y, are two of the most likely to cause the most serious distress, and we would say harm. Ground 3, page 67, that is the ground, and you would have gleaned this, that the Guardian was extremely concerned about. I will not go into the details, but I will know that having read the documents, all of the documents, including the Guardian's analysis, including, of course, what the judge said when trying to assist the criminal court in arriving at a decision in respect of an RRO, there can be no doubt, and the judge did say that any judge would want to protect these children, so she did acknowledge that, but we say that when it came to doing the balancing act, the ultimate balancing exercise of Article 8 and Article 10, the judge, the Article 10 trumped the Article 8 rights of the children and of the carer. There were two sets of Article 8 rights here, but from the children's perspective, the judge's position was, well, this public interest point on private fostering arrangements is so important. It's a huge public interest point. It's not covered much, really, so I think the balance tilts very clearly in favour of that. We say that the balance should have gone the other way, because in this case there is direct evidence, which doesn't always happen in cases, serious direct evidence. The circumstances of X and Y on the ground and their living arrangements and their carer also provide fertile land for the Article 8 rights, as it were, to tilt the balance the other way. And so concerned was the Guardian, and the judge endorsed this, to be fair, that the children weren't told of the application because of the concern about the effects. And in code, your ladyship will understand that the meeting that they had was extremely concerning and difficult in August, on the 10th of August. So we say that on the specific facts in this case, and after all, it is a fact-specific balancing exercise for these specific children on these specific facts, that the Article 8 rights, once you got to the balancing stage, the judge got it wrong. She didn't give enough weight to those rights, and she allowed the public interest in reporting something that isn't part of, we say, the family justice system to take precedence. Finally, in terms of the case of Newman, another one of your ladyship's decisions, that was considered during the course of the hearing, and I think Ms Strong and I addressed her on that, and I think, to be fair, Mrs Justice Lieven refers to it in her judgment. The point about that, which was being made to Mrs Justice Lieven, is that actually Newman was quite similar. I appreciate that the journalist in that case was trying to access thousands of documents with private information. But in this case, the journalistic purpose is investigative. It's similar in the sense that they want to look at the papers to see if there's anything in the decision-making process.
Yes, what happened in Newman is that there were care proceedings at first instance when the recommendation to the judge or the care plan was for a placement order to be made for the child in question.
Yes.
The matter came in front of myself and 2 others in the Court of Appeal, and we allowed the appeal and remitted it, and were quite had some clear views about how it had come about that the placement order was made at all. So off it went back to be remitted to be heard at first instance, and in fact that never, my recollection is that there was never a hearing, because the local authority then engaged with the mother to have the child rehabilitated to her, by which time the child had been away from the mother for 3 years, or thereabouts, if my recollection serves me. What Ms Newman was seeking to do, the focus, a very legitimate focus, and I think I said in the judgment it was legitimate focus, was to figure out the decision-making process which had led in the original decision to have a care plan for a placement order.
Yes.
As opposed to what had actually happened during the course of the care proceedings, although they were related much more closely than you say is the case in here.
Yeah, there's a clear analogy, we say, because what is sought ultimately is to step outside of the court arena and to look at how the placement came to be and what the local authority were doing about it. That has been widely described as a decision-making process of the local authority as it goes in this case. So we say that it's analogous to Newman. There's a very clear analogy. And as you said, in that case, it's not pushing the bounds of transparency of family courts. It's nothing to do with the transparency or functioning of the family court or the family justice system. I think it was referred to, and I think Ms Strong and I referred to it as the archaeological dig or the mining. It was also referred to as a fishing expedition. Let's have a look at the papers, see what we can find. And I don't mean that in any form of criticism, because obviously the BBC will tell you in a moment, I'm sure, that this is a purpose that has value. But it is very similar to Newman, which is what Ms Strong and I were trying to say to Mrs Justice Lieven, is that it's similar. They're on similar tracks, actually. And therefore, why doesn't the authority of the Court of Appeal apply? Because this is exactly what's happening here. I think that the public domain point might have been slightly difficult, but we say that it was very similar, and that the judge attached little weight, if any, to Newman, albeit she did recite it in her judgment. There was also the learning review, which seemed to factor in her reasoning on a fairly high level. Yes, there is a learning review. Yes, though you would have seen that the information in that really has been, the phrase that we've used is stripped of all its details. So on the face of it, you wouldn't be able to identify X and Y. What was said on behalf of the BBC, and I'm sure will be expanded upon in a moment, is that in the statement from a local authority, there was some connection link where it would take you to potential understanding of what that case was about. We say that that may be, but trying to piece all the pieces together is a tenuous link. So even if you have that learning review, it doesn't lead you ultimately to any more information about the children. So although it was important in her balancing exercise, and this was another, it's out in the public domain, when she analysed what was actually out there, there was very little she could point to in terms of the children. And we say that's the same. What the BBC says, well, it's obvious from that at length that the children were the subject of oversight by the local authority, which had not gone very well. I'm putting it, of course, as neutrally as possible. But actually, it still doesn't identify X and Y or any others. And also, the other thing that seems to have escaped the radar is that there are other children aside from X and Y. That's a really important factor that the Guardian, through me, was keen to point out on the 6th of December, that there are not just X and Y here. There are a raft of other children who could be impacted. My lady, I think, looking at the time, I've probably had sufficient time on my feet, but would you give me a moment just to turn my back? Yes, I think I did it the wrong way around, but I covered the open justice principle point, which is our ground number 4.
Understood.
So on that, anything else, my lord and my lady?
Yes, just one thing that we'd like you all to think about. If we gave permission, clearly the BBC have got to be in a position properly to prosecute their respond to the appeal, which inevitably means they've got to have the disclosure of certain documents, subject, of course, to any undertakings and restrictions that might be placed upon them, so that they can properly understand the case and respond adequately to the appeal. I don't know if, and we've certainly had some preliminary thoughts about if we did grant permission, what would be the absolute minimum that would be necessary in order fairly to allow the BBC to respond. Has any consideration been given on your part?
No, I have to confess, no. We haven't done that. Probably we should have, but we haven't. So I apologise for that. But certainly it's not something we've thought about either together or apart, if I can use that. But I'm sure it's something that we could contemplate. If you don't, obviously, on the basis that we don't need to do it now, but
No.
you have some preliminary thoughts. We're likely to be guided by the court, of course, but certainly it's something we can discuss as a group.
Well, certainly it seemed to us, subject to us granting permission, obviously.
Yes, of
obviously
course.
haven't heard Mr Barnes yet, that the Kafkas report and the district judge's judgment were two very obvious documents. Subject, of course, Ms Strong looks very anxious about that, but I think I did already say subject to undertakings and restrictions. I'm talking about disclosure for the purposes of responding to appeal, not for publication, which is, of course, completely different.
Yes.
It's a separate application again.
I mean, first, sorry, forgive me.
Sorry, the other document we would like your thoughts about is I'm looking at the bundle, core bundle, the appeal bundle that everyone's got, at page 102, where the local authority had done extremely helpful. It's the skeleton argument, and it was the synopsis of what's contained in the care bundle.
Yes.
I've been through that myself because I wanted your help and the local authorities' help about it. But looking at what's called section C,
Yes.
that seemed to me to be a document that would be subject to argument.
I can see that. That's the sweat, I believe.
Yeah. So anyway, those were our preliminary thoughts that we thought you should have a chance to think about, all of you.
Well, thank you very much, my lady. Is there anything else I can assist you with?
No.
I'm so sorry.
No,
Anything else?
we're just talking about irrevocable undertakings, but we've not got anywhere near that yet because, of course, we haven't made the primary decisions yet.
Very well, then I'll sit down.
Thank you very much. Mr. Barnes.
I have anticipated that the other respondents who I think
Yeah.
are
So that you
aligned
could go
with
last.
Appellant
Certainly.
might
Yes,
perceive
well,
that
that's-
I'm in my lady's.
No, that's
That's right.
yes, I think that must be right. And when it's 3 against 1, it's only fair you go last.
My lady, I'm conscious that of our position at this hearing, namely
Yes.
that we are not the ones that are seeking permission to appeal
Understood.
ourselves, but we have been directed to attend, so we are in the court's hands, as it were. Perhaps it would assist if I could address this point about the 25th of October hearing.
Certainly, that would be most helpful.
Our opposition to the application at that hearing was based squarely on the way in which the application had been drafted by the BBC at that time. Hopefully you've seen there were copies of the actual original application notice that were included attached to the Guardian submissions. That was where we placed our emphasis. So, and I'm going to try and take great care with this, but the BBC said that they were applying for transcripts and documents from the family court hearings, including the hearing that placed X and Y within the care of, I'm going to call her, person A, and a mention of the proceedings, etc., that followed. Then we are applying to view and report court transcripts, judgments, orders, together with case summaries and other documents drafted by advocate. These will allow us to see what assessment was made of person A and whether the local authority monitored the placement of X and Y. And then in the skeleton argument that was placed before the court, it was further expanded upon as the BBC wants to understand and to report as appropriate on how X and Y were allowed to be put in a position with person A. And what, if any, level of monitoring of that situation was carried out by us as the relevant local authority. So it was based squarely on the understanding, essentially, that there was involvement by us as a local authority and or by the court in playing some role in the determination of I don't want to call it a placement because we don't accept that it was actually a placement. That was the point that we took below, because it was never something which was determined by the local authority itself. It was a private arrangement that was put in place, as you know, before the care proceedings started. But that was what it was predicated on. And that is why in the first instance our opposition was based on the fact that there was never any assessment of person A within the proceedings. X and Y were never placed with person A. And that there were no determinations by courts, therefore, about anything relating to that private arrangement. I won't take you to the actual application notices. I'm sure, my lord, you've read those.
We have.
If I can take this point about the freedom of information request. That issue, and I've checked with my instructing solicitors behind, we don't recall that issue as such having ever come up. Of course, there are alternative ways in which the BBC can try to obtain information, given our position as a public authority. But the simple fact is that there was never any such application. So it was not incumbent on us to try to explain why they couldn't have obtained it through other means. We weren't faced with that application. That's not something that was considered. I should say that, coming full circle, the opposition that we ran at the first hearing really aligns with the dring point. It's the dring point is putting it in a more detailed way and aligning it with the case law on the open justice principle. But essentially, our argument amounted to the fact that you wouldn't see anything to do with the workings of the court procedure because the relevant facts that they sought information about simply weren't part of the court's decision making. And what happened at the hearing on the 25th of October, as you've possibly gathered from the paperwork before you, is that there was a decision made to grant a short adjournment in order to obtain relevant evidence. That's all it was about. And then my learned friend, Ms Brereton, has already addressed the court on how the BBC's application was modified after that point in time. But that's not what we were faced with at the 25th of October hearing. Is there anything else I can assist with in terms of that hearing, I appreciate you didn't have the skeleton arguments, unfortunately, in your bundle that were relating to that initial hearing.
No.
No, that's most helpful, Mr. Strong. Thank you very much.
I'm grateful. And if I might just add, I don't wish to repeat what my learned friend said about the grounds of appeal. There is one point I would like to address the court on, which was the point about Mrs Justice Lieven, in effect, going off and doing some Googling on her own. That I made the point in our document that we lodged, which I called a position statement, further to the court's invitation, that we lodged something to that effect. That it was improper for her to have gone off and undertaken that exercise. Had she wanted to understand and make a determination about what was within the public domain, and properly within the public domain, noting the comments my lord made earlier on about this issue, about truly what that means, that what she ought to have done is invited evidence to be put in on that point. It's quite important to understand that what Mrs Justice Lieven asked the parties to do after the 6th of December hearing was to provide a short note on case law which might be relevant in the circumstances where the court might want to restrain information, where she referred to the information or much of it already being within the public domain. So what she was inviting were legal submissions on this issue about what happens when you want to, is a court allowed to restrain in those circumstances. And in my submission, what she ought to have done is first invited evidence on the question of what was within the public domain. And only then, once she'd made that determination, or indeed simultaneously, asked for invited submissions on this the legal position, which is where all the submissions about PGS arose. And again, my learned friends already addressed that point, and we would simply endorse it. But that was a great concern on our part. I should say, had this have been raised at the hearing itself, we would of course made the point that I've just made, but because this was all done subsequent to the hearing, we didn't have any ability as such through a hearing to make this point known, as it were.
Thank you.
Unless I can assist the court further.
Thank you very much. No. Yes, Mr. John.
Lady, thank you for the invitation to attend this hearing. Of course, we play a rather peripheral role in this appeal. We pray and aid our skeleton argument at page 76 of your bundle and the 2-page note that we handed through last week.
Thank you.
The application is fully supported by my client, the children's carer, of course, and we have emphasised their vulnerability and my client's current circumstances, which are set out within your papers. And we strongly my client strongly opposes, of course, the application by the BBC. And we also make reference to the judge's comments about the vulnerability of the children at paragraph 37 of her judgment, page 40 of the bundle. In relation to the second ground of appeal, and in particular paragraph 49 of the judgment, again, we respectfully align ourselves with the submissions made by Ms Brereton, King's Counsel. But it's clear from any objective analysis of that particular paragraph that there was insufficient balance or weight attached to the prevailing rights both of the children and of the carer, and they are rather throwaway comments in relation to findings of a very significant interference with the media's Article 10 rights, quite apart from the principles of open justice and dring, and reference to the case of Stedman, as has already been made clear. We simply say in those circumstances the analysis was flawed and consequently wrong. My lady and my lord, in relation to the documents that you've identified, I'm sure between us at the bar we can agree those are the sensible things. I don't have anyone to turn to, but unless there's anything further I can assist you with.
Thank you very much. That's most helpful, Mr. John. Yes, Mr. Barnes.
My lady, thank you. If it pleases the court, I obviously act on behalf of the BBC. I'm accompanied by my instructing solicitor and Miss Berg, who I suspect will be very familiar to my lady in other proceedings. The other journalist who was involved was unable to attend today when the matter was relisted. But
Yes,
otherwise,
well, I should have apologised to everyone for that. But
no, well, obviously we were very grateful for the very swift relisting of the matter. Obviously, judicial availability sometimes comes and goes.
that was our challenge. In addressing the matter, I'm obviously conscious that the matter is listed for
a permission hearing alone and
Absolutely.
not full argument. And of course, if the court is minded to grant permission, there will be a chance for further and additional particularisation. So in terms of addressing matters, I don't intend, subject to obviously how I can assist the court, to necessarily go into the same depth at this stage when to an extent matters may develop. But I did want to firstly note that as has happened with the drafting of the reporting restriction order to preserve the position within the course of these proceedings, I hope my lady and my lord will take it as read that the BBC have sought positively and constructively to engage with that process to provide understandable protection. And equally, if the court is minded on granting permission to disclose documents, the indication I have is that there's no difficulty with providing the requisite undertaking in order to facilitate full and proper argument, which we say advances the case if it gets to that stage. I should underline.
That's all we'd expect from the BBC.
Thank
So
I should underline, we say it shouldn't get to that stage. I'll obviously
Understood.
develop that in due course. And there is an interesting observation that I would make, which is that insofar as I think my lady has seen the order which sets out, by reference to numbers within the bundle, the documents that ultimately were disclosed or were intended to be disclosed by Mrs Justice Lieven's order, there is obviously a strong degree of overlap between those matters, those documents that my lady's identified, the judgment, the initial analysis, the initial social work statement, that the court has identified as necessary in order to run the argument per se. I say that only to note that it might be suggested that is a good reason why the manner in which the learned judge ultimately arrived at a conclusion was an appropriately balanced recognition that those were documents that were significant and did satisfy the Dream principles. And
It's a bit of a bootstraps argument, isn't it?
but I think in a sense, what is in my submission clear is that the core of what the BBC were seeking to achieve wasn't actually amended, because what they came to the court to do and sought before Mrs Justice Lieven to do was to give effect to their intent to report on the case.
well, what's
That
the
included,
case?
well, and that I respectfully I submit is where the attention the court has focused on paragraph 51 is important. The BBC came to the court saying, we are aware of other information which we seek to triangulate. We are aware that there were care proceedings. We intend, because that is reportable within the context of the Section 12 Administration of Justice Act framework, to report on the case. We seek to do so accurately, and that leads, for example, to the order that discloses the orders made and the judge's judgment, arguably the most public-facing of all of the documents which are produced in private family proceedings, not least because they are documents, or certainly in relation to the orders, that are specifically permitted to be published in the framework of Section 12, in order to do that responsibly and accurately. Now, as it transpires, that desire to triangulate information in a responsible and accurate way led to a greater and clearer understanding of some of the mechanics that had been addressed to some extent in the criminal process, but in certain respects were clarified and corrected. Now, that goes, in my submission, to the heart of why the first point in paragraph 51 Miss Justice Lieven addresses is that it falls squarely within paragraph 43 of Dring for this case to be reported, in the sense of the care proceedings, to complete the jigsaw that the BBC has put together with the other information that it is triangulating. And that to do so...
This involves the proposition which the judge accepted, that there's an important public interest in understanding the whole picture.
And so, for example...
And if that's so, then the court file can be used as a resource to fill in one of the jigsaw pieces. That's an important proposition in your note that really goes arguably outside the scope of the Dring principles as expressed in that case and says, well, open justice is about something broader than just the case, or even just how judges decide cases in this context. You talked about the framework of laws and the manner in which local authorities discharge safeguarding functions. Now, those are quite important points. If that's the scope of the open justice principle, it looks a bit bigger than it looked when I read Dring for the first time.
Well,
And if it's right, then it's an important point and we should hear it.
well, I'm not sure that this case requires that aspect. We were asked to address, in broad terms, the engagement of the open justice principle. The ground that I would stand on is that, given the way in which that principle is about enabling an understanding and an appreciation of the rule of law, that to tightly and artificially constrain it might run counter to the established principles. For example, in some of the Strasbourg jurisprudence quoted in Guardian News and Media, for example, which talks about not erecting artificial barriers to information. But the core of this is that, in this instance, there is a very serious case. There is extensive reporting about some aspects of that. One piece that is not known to the public is the existence of contemporaneous proceedings before the family court, which the BBC is aware of. And it is, in my submission, very difficult to see how the provision of information to allow that reporting to be accurate in any way does anything other than obviously advance the open justice principle. And to that extent, I would respectfully submit that where, for example, there are children who have faced exceptionally difficult circumstances, and where, as was asserted in this case, in the course of the Guardian's analysis in response to this application, that has been dealt with competently and conscientiously by the family court, and that is an important facet of the public's broader and fuller understanding of that family justice system. So I say it is difficult in a principled way, I say, to constrain that principle.
Well,
but even on a narrow basis, we say it satisfies the test in any event.
I think one needs to be clear here that the issue that is being raised by way of the amended grounds of appeal, round 4, is not whether the BBC should have access to this information. Stop. Because it may have a right to have access to this information by a different route, and the public interest which the judge found to weigh heavily in favour of access to this information may be vindicated in a different way. What we're considering here is whether it's vindicated by the open justice principle.
Yes.
Could you just explain a bit more fully how the information would allow your reporting to be accurate?
Well, for example,
I mean, how would it be inaccurate in the absence of this information?
well, we
What's the risk?
we are able, through tracking the orders, to understand the evolution of the different orders that were made by the family court in an accurate manner. That encompasses proceedings that lasted some 18 months. We are aware, for example, of when they commenced. We are aware of when they concluded, and the broad framework. But between those two poles is a relative dearth of information. Critically as well, one of the key decisions that was made, obviously one aspect is the ultimate determination for which the judge provided the access to or intended to provide access to the judgment that was delivered. Now, when a friend says that the arrangement, if that's a happy compromise, was barely touched on, not looked at, we say that doesn't appear to be the case when one looks at the local authority's documentation, insofar as the conclusion of that arrangement is intimately connected to the...
Sorry, I don't know. I don't follow that. I've still got page 102 open.
Yes.
And I'm not sure how you're saying that.
Well, the outset of these proceedings...
That placement with person A, not placement with person A, had anything to do with the care proceedings as they evolved. Because you've been told very clearly that it wasn't a placement, it wasn't supervised by the local authority, and it had come to an end prior to the commencement of care proceedings.
Well,
So-
that's where I say the intimacy of the connection is, that in fact it is the termination of that arrangement that is the genesis of the proceedings. And that is why it is perfectly understandable, for example, that when the local authority describes the documentation, that initial social work statement placed before the court as the basis on which the local authority pursues its initial applications deals significantly, or certainly on the basis of that, addresses aspects of that arrangement as part of the evidence that went to informing the court's decision-making at that very first hearing. This is not simply the judgment, but that information was before the court because it was the trigger point. It is also something that is plain from that documentation, is revisited in turn with the children in the context of their own experiences within that arrangement. And insofar as it then, as we understand, is referred to in the course of the final judgment, continues to have some impact or some relevance in the course of the proceedings as a whole. So that's why we don't have access to the document.
You're in difficulty.
So I'm peering through
You're drawing
peering through a
inferences.
glass dark.
You're in some difficulty, aren't you, drawing inferences which are contrary to what you've been told.
But it does appear inevitable from what we understand that the trigger point is the end of that arrangement.
That may be
That's
right,
in
but
dispute.
all sorts of things are trigger points for other things. Doesn't mean that the trigger point is of any relevance or any materiality to what happens thereafter. It may be mentioned as part of the background, but it's not surely part of the open justice principle that everything that's mentioned as part of the background to proceedings which are subject to Section 12 is sort of amenable to the open justice principle if the BBC happens to find it interesting to know about it. And has a good public interest reason for wanting to.
Yes, and of course, insofar as one is disaggregating the different aspects, what Mrs Justice Lieven distinguished rightly in my submission is that there is a public interest in this case, the functioning of the court more generally, the disposal, the proceedings that took place in the particular context of a case that has been subject to reporting. There is a particular public interest in an aspect of the case. The two don't necessarily have to be a perfect overlap in order to both be relevant to the different stages of the inquiry, first of all. But I say also that in relation to the manner in which the open justice principle is advanced, the court has, when it's considering what is, of course, a balance that is set out by Dring, two clear findings that the judge makes. The first being that the application falls squarely within paragraph 43 in relation to this case, and then secondly, there is a very strong public interest in an aspect of it. But she also makes plain that insofar as the disclosure of documentation, which doesn't form part even of the amended ground, insofar as the disclosure of documentation itself is concerned, when the court is engaged in a balancing, the actual harm of disclosure of that documentation in the context of family proceedings where it isn't without more reportable is limited. That's not the battleground of harm. The harm might arguably flow from reporting or not. And so when one is considering the balance that is set out within Dring, the manner in which it's being addressed presently by the appellant addresses only one side of it. And in my submission, the court is fixed with two findings, one of which is it falls squarely within paragraph 43 of Dring, and the second is that the actual disclosure of documents itself doesn't have a countervailing argument that overrides it. And that is the basis on which I would respectfully submit, in relation to that ground, that potential ground, and I'm obviously inordinately deferential to the fact that my lady invited submissions on the point. I understand entirely why the matter was then canvassed and looked at, that in my submission, it isn't a point that is arguable in the context of this appeal sufficiently to justify grant of permission, and where the court is fixed with those twin findings, if it is a point that might arise and be of interest, this isn't a case where there is a compelling need to consider it in the context of this appeal. Because in broad terms, what I say is, Mrs Justice Lieven applied conventional principles, she undertook the relevant balancing exercise, she did so on an informed basis, and she reached an entirely defensible position on all aspects. And so, whilst the scope, the narrowness, and so on of the open justice principle may be something that is arguable and of interest, that in this case, the actual grounding in the balancing exercise, as opposed to a more one-dimensional examination just of does it access the open justice principle, we say that to access that open justice principle, given its consequential importance, the need in our submission not to erect barriers to information, that is not the high test, the high watermark, and the central consideration of the judge was the Article 810 balance in the reporting decision, and on that, having considered the relevant case law, the relevant factors, none of which the Guardian lists are absent. They are all considered. They are all considered with care. The judge is not saying these aren't vulnerable children. She's recognising all the aspects of the case that is weighed against the BBC, but she says it's clear that that's overridden in the context of this case. And with respect, applying the approach that this court must on appeal, it is in my submission not just a decision that doesn't fall outside the range of reasonable responses. It is the correct determination that the judge has arrived at, and that in my submission is the basis on which we say the court, having properly facilitated an exploration of not just the issues that the appellant initially raised, but a broader canvas, which in some respects runs directly contrary to the initial argument that the appellant was running, which accepted the engagement of the open justice principle and said, if you're with us on denying reporting, then disclosure is unnecessary. They weren't attacking the disclosure decision. There is a tension in that. In my submission, given the balance of that test, this is not a ground that has sufficient real prospects of success to allow the court to move on. I did want, just because the court has a very extensive authorities bundle, to trouble the court by looking at a couple of aspects of the decision making, of the way in which those authorities might assist. And so with Dring, that appears at 337 of the authorities bundle. I think it's 337.
It's the revised bundle.
Thank you.
And obviously, I suspect, not least because my lady considered it in Dring and the nature of my law expertise, I don't intend to take it other than relatively briskly, and if it's not assisting, I'm very happy to be told. But for example, paragraph 2, that's at the top of page 344. It's about accessibility to people who are not parties to the proceedings, extent and operation of the principle of open justice, endorsing Lord Justice Tolson's very powerful exposition of what the open justice principle is about, it being fundamental to democratic processes, the rule of law, and so on. Open justice lets the light and allows the public to scrutinise the workings of the law, for better or for worse. That's why we say it's artificial to divvy matters up and to some extent to take a view that doesn't encompass at least a broader understanding of the workings and the hinterland as established here. Paragraph 11 on 346, and I suspect my lord has probably seen the ex post facto decision making in Dring back at the first instance. Of course, what's relevant and what was prayed in A there is that even if the application by the forum in Dring was relatively modestly connected to open justice principles, the Supreme Court's decision upheld a very expansive range of disclosure from those proceedings where they hadn't even reached at a final determination. They were ultimately settled. This case, of course, did involve a whole series of judicial decisions, including removal decisions, including ultimate placement, and everything in between, some of which is likely, and in a way that appropriately recognises children's interests, likely touched on in what is permitted by the order in terms of furthering a public understanding of a broad outline of the process. And I say that is of relevance. At 353, paragraph 38, this, of course, is talking about a default position of access, and that particularly engages proper journalistic purpose. And obviously that wasn't what underlay Dring, because the Forum was doing it for their own ends, for other aspects. And that, I say, does ground this in rather different territory to simply Dring, and of course is about the court not exercising an editorial or censorship function in where a chain of inquiries leads when those responsibly pursuing proper journalistic purpose, and it isn't appealed, the parties are fixed with the proper journalistic purpose that underlies this.
I don't think anyone could, well, certainly in the family world, would begin to suggest that it wasn't a proper journalistic purpose to consider how private fostering arrangements work.
But that is a critical underpinning, I say, to the broader analysis of whether you erect barriers that I respectfully...
It's not barriers. The barriers are set up by Section 12
of
the Administration of Justice Act of 1960s. You're turning things on their head. The starting point here is not a set of proceedings which are inherently open and a desire to see what was going on, where the court doesn't function editorially. The basic question is you get everything that the court saw, unless there's a good reason to the contrary.
Yes.
But although the open justice principle applies across the board, it is subject to statutory intervention in this particular context, and that's got to be taken into consideration when we look at Dring, hasn't it?
I accept that the particular context of family proceedings is of relevance. What, of course, is relevant is the reportability of much of the information that we don't have simply because we weren't at the set of hearings that we weren't aware of until later. So there is an issue, which is that you aren't necessarily relying on principled decisions exercising the relevant balancing tests. It is simply that the difficulty of accessing information or identifying cases and so on means that certain matters don't come to attention. Now, respectfully, my counterpoint too, there's a whole series of information that, as my lord has rightly pointed out, is all capable of being placed immediately in the public domain, not least by the BBC, but they are seeking to complete the picture, to report responsibly in the context of that information. If they're denied that information, what the judge is saying is, well, the public has no advantage in them being forced to speculate about that gap.
Well, that's why I've been careful to emphasise, and I emphasise again, that I don't think that this application is to do with whether the BBC should have the information to pursue its journalistic endeavours. It's to do with whether it should have them pursuant to the open justice principle. So to say that barriers are being put up is somewhat question-begging, because there's never been a FOIA application. We have no idea, we have no submissions about whether a FOIA application would succeed, on what grounds it would be resisted, whether on an application to the tribunal you would succeed. So the argument can't be had on the assumption that it's open justice or nothing, because that's begging a very large set of questions about what might happen if you sought the information by some other means.
But it is what's plain from Dring is that material being before the court has the inherent jurisdiction to consider the disclosure of that documentation. It is, in my submission, a proper application that is before the court. That is the route that is being accessed. There are certain advantages in that being the route that is accessed, because my Lord's question about the participation of the guardian, for example, in any FOIA-related application, the guardian is appointed in specified proceedings, and specified proceedings alone. The degree to which the children are capable of having an input and engagement within any other alternative process, I'd respectfully submit, is likely, not inevitably, to be less than the forthright advocacy and representation that they had in the context of this application. I did want, those are the matters that obviously I wanted to draw to the court's attention. There are obviously other references within Dring, and of course paragraph 43 is a linchpin of the judge's decision, we respectfully say, rightly. I wanted to turn to the Guardian News and Media case, which obviously is one that is drawn upon significantly by the Court of Appeal, because there are a couple of quite helpful aspects to it that I say again support the basis on which I might ask the court to find to grant permission. The court has at 240 is where I wanted to take the court first. This is the quote from Lord Diplock, quoted in paragraph 31. I say that the judge's finding as to the interest in accurate reporting and no interest in speculative reporting engages the consideration there that an aspect of the open justice principle is the publication to a wider public of fair and accurate reports of proceedings that have taken place in court. That is bound up in the disclosure that we sought and the documents that were ultimately disclosed. I wanted to draw the court then down to the paragraphs over page 32, 33 and 34.
Thank you.
All of which we say are consistent with the application that we made, particularly the bottom of 34, the access to documentation with suitable safeguards, we say is the essence of the balanced approach that the court ultimately took to limiting it. My lady is...
Sorry, losing my colour coding's gone wrong.
Of course. But the public access to documentation with safeguards is inherent in the care that the judge applies to the scope of disclosure, but also the balanced way in which permission to report was accompanied, again, with the agreement and support of the BBC with appropriate protective aspects that were included in the order, and arguably extended protections for the children in the context of the ultimate application that was made in comparison to where the statutory scheme left matters. Paragraph 49 cites, I'm afraid I will have to, if the matter is returning, work on my Hungarian pronunciation of the case cites at paragraph 48. But it's quoted at 49. Consistent recognition of the right to receive information of general interest. The law can't allow arbitrary restrictions which may become a form of indirect censorship to create obstacles to the gathering of information. And here, it is the difficulty, given that this court is aware of where Justice Lieven ultimately found the balance lies, that in the relatively lower threshold balance, which we say is all one way in Mrs Justice Lieven's consideration, that to seek to deny the disclosure of the information as a barrier to reporting that would otherwise be in the public interest through this application, I accept, is one that is tantamount to...
Well, this is a big point. The understanding of the English courts and tribunals, generally speaking, is that the Supreme Court has held that Article 10 doesn't give you a right of access to information. There may be a slight tension between the approach of Strasbourg and the domestic approach on that front. One of the things that slightly troubles me about the judge's approach here is that the distinction between open justice and Article 10 may have been blurred. And she seems, on one reading of some of it, to have treated Article 10 as encompassing a right of access to information, separately from and additional to the open justice principle. That seemed to be where you were going here.
Well, I think the respect submission I'd make in response is actually the way that the judge disaggregates, making specific reference to paragraph 43 of Dring, having correctly directed herself, it demonstrates that she made the sufficient clear findings as to where that balance lay to be able to discharge that function. Plainly, what was occurring here were two aspects of a process. One of which is to look at, because it's part of the consideration that the Supreme Court gives in Dring as to the proper journalistic purpose that underlies the engagement of the open justice principle. So Article 10 is not irrelevant, and obviously it's highly relevant to the reporting stage of the court's consideration. So inevitably, where the court is considering matters in the round, obviously there is a practical imposition of bifurcating out a process that means repeated and further hearings at each stage where there is resistance, when the judge comes to a clear view favouring the ultimate end point. So that's the basis on which I would put that. I have to say, in terms of the fourth point that my ward raises, there is some consideration of FOIA in the course of Guardian News and Media itself. That's at page 253. I suppose it's only to highlight this, that in Guardian News and Media, the fact that material was exempt from FOIA was not held to be to prevent the court from potentially permitting access to those documents. But equally, I'm not sure that if that approach is one where one respects different avenues which apply tests on different bases, the mere fact of a potential avenue which hasn't been explored, isn't before the court, wasn't argued, certainly wasn't argued as a defence to the application, I'm not sure is a basis, particularly given the scope of the appeal, that necessarily is taken further than saying, applying these principles, it was available, the court had a jurisdiction to consider it, considered the relevant test, and made the findings on both sides of that balance that favour the disclosure of documentation. The other important aspect of the Guardian News and Media decision was the emphasis that it gave to the importance of the open justice principle giving access to material and facts that might, though not necessarily directly, engage a substantial public interest. And in a sense, that is where the access through these proceedings, and reporting these proceedings, giving rise to an additional, highly significant public benefit, is one where we say that is consistent with the approach that the Court of Appeal took in Guardian News and Media, and which was obviously an important underpinning of the Supreme Court's decision in Dring as well. The ancillary benefits of applying that of applying the open justice principle of providing the relevant documentation is not an irrelevant consideration. It is a benefit and a practical purpose and consequence, and highlights the importance of the open justice principle. And again, I respectfully submit it goes towards not artificially constraining its application and scope in the way that the Appellant's revised case would appear to do. So, again, I'm conscious I don't want to go beyond assisting the court into something, but I'm happy to assist in any other.
No, well, I think we're very clear about your structure and approach to
of course.
the application.
I think the only other aspect, depending on obviously the court's decision, there would need to be engagement, and I suspect some direction from the court and oversight of any scope of disclosure of documentation. On the other hand, and one aspect that obviously the judge found was broadly consistent with the open justice principle in any event, was the publication of her judgment, falls to consider in due course potentially publication of any permission decision and of course potentially the appeal. And mechanically, if my lady and my lord are with me that permission should be refused, of course there arises the process by which the matters are given effect. This is obviously an application that the BBC has considered in detail and with an intent to report, as my lady and my lord know, in circumstances where, because of the stay that my lady imposed, the documentation hasn't been accessible to them. To that extent, we would appreciate some degree of flexibility in terms of outcome and publication to ensure that we are able to consider material if that is ultimately where the court is upholding the decision of the court below in a way that allows us to meaningfully engage with timely reporting that doesn't undercut the whole purpose of it in a sense. But
yeah.
those
yeah, I mean this is a problem that arises in any case which is to do with information that's not already accessible.
Yes, of course. I should say, for the avoidance of doubt, I very much adopt my lord's analysis and the response in relation. I don't think I've touched on the reporting restriction order, but with respect, the judge's decision engages with the Article 8.10 balance across a range. It's quite plain why the judge took a firm view that the reporting restriction order wasn't capable of being justified in this case. I note it was the oral application hasn't been followed up. The terms and scope of it haven't been engaged on, but the judge was right to point out that the notion of restraining information that's been aired in the course of criminal proceedings, that is available in a published document in relation to the learning review, and that restrains that comprehensive reporting in a case that had already been heavily reported, is unsustainable, and all the more so in the context of her own view of the balance of harm versus public interest in the Article 8.10 balance. So it is advanced slightly curiously on the appeal in that it doesn't directly say the judge's decision was wrong. We say that the application was rather modestly advanced. It wasn't, I don't think, even addressed particularly by the guardian at all. It was something that the father had, that the care floated. But it was one where it was appropriately managed, and the judge's reasoning for refusing the same was clear and, I say, unimpeachable. But unless I can assist further.
Yeah.
Anything in reply?
No, nothing. Thank you very much.
Then I think we'll rise for a few minutes. Shall we say 10 minutes, and then if people just want to leave the court for a few minutes, everyone can do so.
Just to let everyone know the live stream is still on.
Okay, thank you.
3 weeks, frankly.
Oh, really? Oh, that's great. Great colours.
Great character. Absolutely large from life in every sense of the word, isn't it?
Was that Norton's going to sound like this?
That's the family case where a woman had, a Ukrainian woman who had abducted the children.
Or five disabled.
My Lord Justice Warby will give the judgment to the court.
This is an application for permission to appeal against an order made by Mrs Justice Lieven on the 20th of January 2025 in care proceedings under the Children Act 1989 concerning 2 children. By the order under challenge, the judge granted an application by the BBC for 1, access to documents in the proceedings, and 2, the partial variation of the reporting restrictions imposed by Section 12 of the Administration of Justice Act 1960, so as to permit reporting of specified kinds of information drawn from those documents. The application is made by the guardian of the children, acting as their litigation friend. The application is supported by the individual in whose care the children have been placed by the court, whom we shall call the carer. The local authority also supports the application, and the application is resisted, unsurprisingly, by the BBC. We've used generic terms to refer to the parties other than the BBC because that's necessary to ensure that the proposed appeal and this application are not rendered futile by disclosure of the very kind that is in issue. For that reason, there is in place a reporting restriction order, and for the same reason, the account of the background that we give in this short judgment must be in broad and general terms. The background, in short, is this. Some 3 years ago and more, the children's mother arranged for them to be looked after by a friend of hers under an arrangement which all parties agree was, as a matter of law, a, quotes, private fostering arrangement, close quotes, within the meaning of Section 66 of the Children Act. After about 4 months, the friend gave the local authority notice by her conduct that she was leaving the jurisdiction and could no longer look after the children. The local authority promptly initiated care proceedings in the family court. On the 1st of April 2022, an interim care order was made. Shortly afterwards, the children were placed with the carer. The care proceedings came to an end in August 2023, when an order was made placing the children with the carer under the supervision of a different local authority. Events in 2022 and 2023 in which the children were not involved prompted 2 BBC journalists, Ms Berg and Mr Puri, to take an interest in the way the children had been cared for by the mother's friend and the role of the local authority in respect of those arrangements. On the 4th of October 2024, the journalists, or the BBC on their behalf, applied to the family court for A, access to various documents relating to the care proceedings, and B, permission to report the contents of those documents, subject to certain limitations and restrictions which were designed to protect as far as possible, the interests and rights of the children. The application was transferred to the High Court and came before Mrs Justice Lieven, whom we shall refer to as the judge. When the application was first made, the BBC knew little about the care proceedings and the involvement of the local authority in the lives of the children. The BBC believed, and the basis of its application was, that the children had been placed by the local authority with the mother's friend, following an assessment of the friend by the local authority. As we have mentioned, the reality was that the decision to place the children with the friend was one which the mother had made privately without the local authority's involvement. Upon appreciating this, the BBC amended its application and the grounds upon which it was based. The amended application came before the judge for hearing on the 6th of December 2024. In its skeleton argument for that hearing, the BBC put its case as follows at paragraph 24, quote, "Focus of the application. The BBC makes clear that its central focus is on investigating with a view to reporting on 1. The circumstances in which the children came to be cared for by, open brackets, the friend, close brackets, for a period of some 4 months. 2. The degree to which the local authority fulfilled its fundamental safeguarding role. And 3. Understanding the children's experiences in, open brackets, the friend's care, close brackets. It is that clear focus that forms the basis of its amended application," close quotes. The judge heard argument from counsel on behalf of the BBC, the local authority, the carer and the guardian. She gave a reserved judgment on the 15th of January 2025, by which she upheld the application. Her reasoning may be summarised as follows. 1. To resolve the application, the court had to apply a balance between the Article 8 rights of the children and the carer, and possibly other third parties, and the Article 10 rights of the press to report. The outcome would depend upon a detailed scrutiny of the rights engaged, with what the judge called, quotes, "close regard," close quotes, to the rights of the children. 2. Although the disclosure sought would amount to an interference with the children's privacy rights, it would not add a great deal to what the BBC already knew and was free to publish anyway. Granting the BBC access to further information and the freedom to report upon it would not add materially to the harm that the children would suffer. 3. There was also a real public interest in, as the judge put it, quotes, "reporting on this case and the circumstances which led to the children being in, open brackets, the mother's friend's, close brackets, care," close quotes, and certain other issues, including, quotes, "interagency working and school oversight of children," close quotes. To grant the order sought, said the judge, would be in accordance with the principles identified by the Supreme Court in Dring and Cape Intermediate Holding Limited, 2019 UKSC 38, 2020 Appeal Cases 629 at paragraph 43. 4. In these circumstances, the Article 8/10 balance tilted, quotes, "quite clearly in favour of allowing reporting," close quotes. In its original form, the Guardian's application for permission to appeal raised 2 main points. It was said, firstly, that the judge got the balance wrong in 2 ways, by attaching too much weight to the relevant information that was already in the public domain, and by giving insufficient weight to the evidence before her about the impact that disclosure and publication would have on the children. Those were grounds 1 and 3. It was also said, under ground 2, that the judge had failed properly to address or to engage with an application made on behalf of the carer for a reporting restriction order. The carer and the local authority support those grounds of appeal. In response to some queries raised by the court, the local authority, the Guardian, applied to amend her grounds of appeal to add a 4th ground in the following terms. Quotes, "The judge's decision was wrong in that A, the information sought did not fall within the purposes of the open justice principle as set out in Dring. B, the private fostering arrangements had ended before the commencement of court proceedings or the involvement of the family justice system and did not form any part of the court's consideration and decision-making. C, the parameters of the open justice principle were extended to include the workings of local authorities / the wider child protection system out with court proceedings, end quote. This additional ground and the application for permission to add it were both supported by the carer and the local authority. The BBC initially resisted the application for permission on the basis that the point had not been argued below and we should not allow it to be raised now, and in the alternative submitted that we should reject it as unarguable. Today we've heard helpful submissions from all parties and have reflected on the matter. Without opposition from Mr Barnes on behalf of the BBC, we concluded that there should be permission to amend the grounds as sought. We are satisfied that the issue of whether the open justice principle lent support to the disclosure application was the subject of argument before the judge. It was in any event an issue that was before her for decision, and Dring was one of the cases she considered and relied upon as part of her reasoning. Ground 4 is thus a legitimate ground of appeal. Having heard the argument, we're not persuaded that there is any arguable merit in ground 2. The carer applied orally for a reporting restriction order to prohibit in substance any reporting at all about the children. The judge declined to grant such an order on the basis that it would be wrong and futile to impose restrictions on the reporting of information that was already in the public domain. She gave a sufficient consideration to the competing factors in doing so. It's not arguable that she was wrong. We have, however, concluded that permission to appeal should be granted on grounds 1, 3 and 4. In our judgment, ground 4 has a real prospect of success. It is arguable that the judge's approach did not accurately reflect the scope and specific purposes of the open justice principle. Important issues are raised. If ground 4 were to succeed, the others would fall away. However, if ground 4 failed or was successful only in part, it would be appropriate to consider the judge's decision on how the balance should be struck. This court's function in such a case is one of review. It does not re-hear the case with a view to taking its own decision, regardless of that which was decided below. But we do consider that the Guardian has a real prospect of persuading the court that the judge's approach to the balancing exercise was materially flawed in the ways relied on in support of grounds 1 and 3.
Thank you. So then, so far as case management is concerned, I would suggest first of all that all, if I might call it, the basic directions that inevitably follow the granting of permission to appeal will be dealt with administratively in the normal way.
Yes.
Through the Court of Appeal office.
Thank you.
Obviously, any applications for extensions and for filing documents and so on can be dealt with in the normal way. So if everyone's content about that, I don't think we need to start worrying ourselves about that.
No.
But I think it would be useful just to think about time estimate.
Yes.
I think it's 2 days. Yeah, well, we're just debating whether it's 1 day or 2 days. I have said from my part, one of the reasons that I was thinking it may be 2 days is it is the sort of case where we might get applications for interveners.
Yes.
Does anyone have a view about that, strongly held or otherwise?
I think that the risk of having interveners, and they may well pop up, does extend it. Otherwise, I think we could probably deal with it in a day, but I think you're catering for possibilities with 2 days.
Yeah, Mr Barnes, you content with that?
Yes, I'm conscious that part of the court's directions are like to be the need for the appellant to have the opportunity to formulate the skeleton argument, and obviously, given some of the territory that the appeal now arguably covers, I can understand the court taking a cautious approach in listing the matter, though obviously I'm conscious that the application was made in October. It does engage with matters that would otherwise be reportable. So there is obviously a balance to be struck between a proper time estimate to allow the court to consider matters, but not delaying matters.
I perfectly understand, and I'm for my part, as the supervising Lady Justice, I'm conscious of the need for this case to be heard as soon as practical.
Well, I know that the court has obviously considered this at speed and considers other matters when necessary, but I think that's the only balance. I simply don't know in terms of availability what impact that might have.
Thank you. A small matter, but it did occur to me that the way things now are, you may want to reformulate your grounds of appeal. Don't panic, Mr. Barnes, she's not going to amend them again. So your current ground 4 becomes ground 1.
Yes.
I just think the point of view for everyone, for their arguments and any potential interveners, that would be more logical.
That makes perfect sense, lady. Thank you.
Now, so far as those documents that we already briefly referred to, which will have to be disclosed to the BBC to enable them properly to respond to the appeal. Now, I've said the 3 documents in particular that our initial thoughts were, but you've not had an opportunity, any of you, to think about this and to consider it, nor have you had an opportunity of thinking about the terms of undertakings and restrictions on to protect the identity and the material. I think the proper way to deal with this is to leave it up to all of you to have discussions between yourselves.
Yes.
And in the event that there are any difficulties, you can make short written submissions, and I'll consider further disclosure, or the disclosure, I should say, on the papers.
It did occur to me that the Master Rules practice guidance on interim non-disclosure orders might be a source of some help. There's a mechanism for giving irrevocable undertakings in return for confidential information, which would, if abided by, and I repeat my lady's statement that we have full confidence in the BBC to abide by undertakings of that kind,
Yes.
Would secure the information, allow it to be disclosed for the purposes of the appeal, but with the assurance that if that was the appropriate solution at the end of it, the information would then be destroyed or made unavailable.
Understood. Thank you. Then we will explore that. Thank you very much.
Now, what else do we need to do? What else can we usefully deal with today while we're all together?
Not sure there is anything, but I'm sure if I've missed anything out, one of other member of the bar will stand to their feet and tell me.
Mr. Barnes.
My lady, my only observation is this. It's obviously for the appellant to frame the case advanced on behalf of the children.
Of course.
And that will require some appropriate time to reformulate the skeleton argument as far as the additional now ground 1. And respectfully, I see the logic of the court's position on that in terms of ordering. Plainly, the BBC is going to be then responding to additional observations of the other 2 supportive parties. And I think in the circumstances, given that I don't know the scope of the argument and whether they will necessarily cohere perfectly, and there may be other observations made, whether
You want to go last?
That may be helpful, and I only raise it so that the BBC addresses matters comprehensively in one document rather than any need arising.
That's extremely sensible. I was going to suggest that in any event, and I can't think anyone would object to that.
Well, no harm in asking for a direction.
No,
the lady was thinking
absolutely
of in any event.
We might have forgotten. Anything else, Mr. Barnes? Are you otherwise content with my...
I don't think so for my part. I'm very grateful.
I've just raised the question of the existing reporting restriction order.
Yes.
No one has raised a concern about it, but I haven't looked back at its terms. I imagine that it will continue as it is until after judgment on the substantive appeal. But if anyone...
On the amendment that I made, I think I specifically framed it in terms of either the Commission decision or the conclusion of the appeal.
Yes.
I note, in fact, that it has obviously been published on the judiciary website as is incorporated within that, as at the 11th of March, if there is any need for those terms to be known. So I don't think there's any difficulty with those continuing to apply, save the mental gymnastics of the submissions and piecing matters together in a way that doesn't infringe on the information.
Yes.
Thank you.
Lady, just by way of information really, the Guardian, who as you know has been involved for a significant period, is due to leave Kafka shortly. However, obviously she will make inquiries about coming back, as it were, in order to see this through, but I thought I ought to let the court know that technically she will no longer be a member of CAFCAS from sort of mid-April onwards.
Well, thank you for letting us know. And it would obviously be helpful. A new guardian won't be appointed because there are no proceedings, no care proceedings now. So it would be helpful if she felt able to attend.
Thank you very much.
Unless there's anything else?
No, thank you, Madam.
No. Well, thank you all very much indeed. And again, I apologise that you were all had to jump through hoops to get here, and there was a change of dates, and I'm very grateful to you. Thank you very much.